All right, folks, welcome to what could be your last lecture of the year. And I say could be because it depends on if I get through the whole thing right now or if I talk too much like I typically do in my other lectures, because this might be split into two. But this is chapter 15, which is civil rights. So as you'll recall, chapter 14 was civil liberties. So we're looking at remember the difference here between civil liberties and civil rights, right? So civil liberties are protections from the government. So those are your, like listed in the Bill of Rights. Government cannot restrict most of the time your right to free expression or free exercise of your religion. Government cannot come and take your guns away from you. Government can't force you to quarter soldiers in your home, et cetera, et cetera, et cetera, et cetera. Okay, so Bill of Rights, civil liberties. Civil rights on, kind of the other side of that coin are protections that are given, like statutory protection, statutory meaning laws being passed. So statutory protections given to groups of people by the government. And the goal of civil rights is to create equal footing, or this idea of equality of opportunity. So let's talk about what rights are and the different types of rights, first of all. So you have natural rights. So, and you can see the quotes, I'm doing the air quotes anyway, but we also call natural rights human rights. And those are the rights of all people to dignity and worth. Typically, at least, in modern times, we have a basic agreement on this idea of human rights, that because we all belong to this classification of the human race, that nobody is lesser than anybody else because of different things. Of course, that particular argument sadly has been brought back up in recent times. We had, of course, issues with seeing human beings as human beings back before before civil rights legislation was passed, right? So as we all know from our study of history, African Americans have very much so historically been disenfranchised in this way. Especially, all you need to do is point to the 3/5 clause in the Constitution, right? Which literally said that slaves were not even full human beings. So we have had this debate about natural rights and human rights for a long time. And I think that a lot of people sort of thought we were past it when we started passing civil rights legislation in the 60s. But again, like I said, it's sort of reared its ugly head in the last, 5-6 years or so. And it does it in different ways with different groups of people. But, I always say that, you can be on whatever political side you want to be, but if you don't agree that, people all belong to one race of humans and that nobody is better or worse than somebody else simply like based on the fact that they're human, like if you disagree with that, I can find no common ground with you at that point. So I think that that's where I draw my line, and I think that's where a lot of people draw their line in terms of the political realm, is on this idea of basic human rights. So civil rights civil rights is a right to not be discriminated against based on, right now, it's only the basis of race, religion, gender, ethnicity, national origin. People argue that other things that cannot necessarily be helped, like things that you are, born with or born as, should also be included in that. Things like sexual orientation, gender identity, that sort of thing. The federal government does not agree with that quite yet. A lot of states have included those two things in their civil rights legislation. But in terms of the federal government, that has not yet happened. I believe it's probably coming pretty soon, just because I think that's the wave of the future here. Most people of your generation believe that that should be something that should be included in civil rights, certainly more so than any other generation that we've had. And you point to cases like Obergefell versus Hodges, which upheld the legality of same-sex marriage and that sort of thing. So you can kind of point to that as, this like the direction the country is heading in. But that sort of remains to be seen. Of course, in the 2020 election, I think is like probably super important for where that inclusion goes. If President Trump is voted to a second term, probably you won't see that inclusion anytime soon. If Biden were to win the election, I think that you'd be more likely to see that included in civil rights legislation federally. All right, so civil rights also, like I said before when we talked about the differences between civil liberties and civil rights, civil rights are government protections to ensure equal footing. So to try to get groups of people who have been historically disenfranchised to like level the playing field, to offer this idea of equality of opportunity. And civil rights are constitutionally protected in the 14th Amendment and the 5th Amendment in the Equal Protection Clause. So that has been the basis of civil rights legislation, is that clause that says that no person shall be denied equal protection of the law. And again, that appears twice. It appears in the 5th Amendment and it appears in the 14th Amendment. The 14th Amendment took it and applied it to states, but then also was written in such a way that it was designed to protect African Americans as well. So that's kind of why that, it exists twice. Due process clause exists twice as well, as we've talked about. All right. So, what is equality? That's a really great question. So equality, everybody on its surface is like, I love equality. Everything should be equal. Of course it should be. And people equate equality and fairness, which is not necessarily a good comparison. But the thing is that we have a different idea of what equality should look like and what measures we should take to achieve equality and what type of equality we should attempt to achieve. So when I say it's a divisive political issue, you might be going like, why? Like, why does anybody not think we should have equality? Well, again, because it just depends on what type of equality you're looking at. So when it says greatest consensus is equality of opportunity, most people, like if you were to just stop, 20 people on the street, don't do it, during the coronavirus epidemic, but when that's gone, if when we can get closer than 6 feet away from somebody, if you were to, take a random survey of 20 people and say, hey, do you believe that, we have or that we should have equality of opportunity in our country? I would say that probably, hopefully 20 of them out of the 20 would say, well, yeah, of course we should. Believe that nobody should be denied an opportunity to achieve whatever they want to achieve because of their race or their gender, their, religion, national origin, that sort of thing. But where it becomes politically divided is what we do after we provide that opportunity or what providing that opportunity looks like. There's the conservative argument of, look, the legislation's in place and, it's up to people to sort of like bring themselves up. Like we're giving everybody an education. We're giving everybody like the opportunity to, go to college and, or find a trade that they want to do. And, we have these, anti-discrimination laws with respect to employment and housing and all this kind of stuff. So no matter what, you have the opportunity to make what you want to of it. And then the liberal argument of that is, no, you don't. Because a lot of things, with education certainly are still inherently unequal. Not everybody has access to health care, like very basic health care. Not everybody has, like this idea, like Andrew Yang's idea of the universal basic income, right, which we talked about in class. So, the conservative argument says we've already done, like the legislation does it and it's up to people. And the liberal argument says, yeah, that's fine. You've done it with some legislation, but we also need to provide more to these people because this idea of equality of opportunity isn't necessarily what it should be. So those are two different sides of that. And then everything, of course, in between. Both sides agree that, this focus of like equality of opportunity should be provided more so than, what's called equality of outcome, right? So, if somebody has absolutely no desire to better themselves or to work or whatever, you'd be hard pressed to find anybody, even the most liberal Democrat, to say, well, we should give them, the same things as, this doctor who has, spent 20 years of their life in school and, what have you. So I don't believe that you'd find a lot of people who would argue that equality of outcome is something that, we really appreciate as a country, but certainly equality of opportunity. So the Democrat side of this, the liberal side of this bottom bullet point here, this focus on like individual achievement and then creating equality between groups comes from this idea that our income gap is crazy, right? You always hear about the 1%ers, and how 1% of the people hold 80 to 90% of the wealth in the country, or maybe 95, I don't even remember. But and how do we lift people up, and is legislation enough, or do we need to go further? All right. We have to talk about types of people who are in the U.S., like kind of classify these types of, citizens, non-citizens, and what they have the right to do and not to do. So you have your natural born U.S. citizens, naturalized U.S. citizens, dual citizens, resident alien, illegal alien. I have the asterisk next to dual citizen because technically the U.S. doesn't recognize dual citizenship, but they do not take any sort of legal or political stance against it. So you can be a dual citizen of the U.S. and Canada. Sometimes, some countries you have to renounce your citizenship in another country in order to do that. The U.S. has sort of vacillated on that over historically. All right. So what rights do people have? So natural born U.S. citizen, you have all rights in the Constitution, right? You are granted every single one of those. If you're a naturalized U.S. citizen, meaning you come from a different country and then you become an American citizen, you also have all rights given in the Constitution except for one, and that is that you are not able to run for president. So sorry about your luck there. It was funny when Jennifer Granholm was the governor of Michigan. So of course, you have Governor Whitmer now. We had Governor Snyder before that. And before Governor Snyder's 8 years, we had Governor Granholm. And if you watch CNN ever, you'll see her. She's now a political commentator. For a moment, she was a very popular governor. And then the economic crisis hit and she was no longer. But people were like, she should run for president. And it's like, okay, joke's on you, people who don't know the Constitution, because she's actually, she was born in Canada, so she couldn't run for president anyway. People said the same thing about Arnold Schwarzenegger when he was governor of California. We should have him as president. Again, okay, no, he's like an Austrian citizen or something. But anyway, so naturalized U.S. citizen, all rights in the Constitution except can't run for president. Resident aliens. So alien, not like from, outer space, but alien as in like foreign born person. So a resident alien is somebody who is legally living in the United States, but does not have their citizenship. Okay, so you also might hear them called legal immigrants. They are again, subject to all rights given in the Constitution, except also can't run for president. But plus, they cannot vote and they cannot run for office. And I say office, and I mean federal office. Because some cities and states have made it so that they can run for office, really more so local than any state laws or any national law. But so you could run for, probably school board in some cities if you're a resident alien, but you cannot run certainly for federal office. And I believe most states, you cannot run for state office. And then you have the legal term of what people call illegal immigrants, or simply illegals, which is so offensive, it drives you crazy, but they're called illegal aliens. And so these are people who are living in the U.S. And are not here legally. So they came in, through, who knows, whether they, flew on a plane and got here, in a pretty legal manner, but then just stayed and didn't tell anybody, and you can't do that. Or whether they, crossed over a border illegally, snuck across the boom, whatever. So these are just people who have no legal authority to be living in the U.S., but are anyway. So in theory, they also have all rights that have been granted in the Constitution to citizens, except, again, those excluded to resident aliens and naturalized citizens. So can't run for president, can't vote, can't run for office. Technically, though, they do have all of the rights granted to anybody who is a citizen or resident alien in the Constitution, because the Constitution talks more about place and residency. Like, if you happen to be in our borders, like within our country's borders, then you are subject to our laws. So you cannot say, you can't have it both ways, where you are going to say that an illegal alien can be put in jail or prison or what have you for breaking the law, but then is also not entitled to protection of the law. So that really, and a lot of people don't necessarily agree with that argument. They think that people who are here illegally shouldn't have any rights at all. And some states certainly do deny rights to people. A lot of the southern border states happen to do that a little bit more than we do here in Michigan. But you can't, again, you can't hold somebody to a standard, but then not provide them that standard, if that makes sense. So if you're a child of an illegal alien, you do have access to public schools. You have access to some nutrition programs, right? So like if you were an illegal alien in Marysville, you could probably still go, if you had free and reduced lunch, you could still go get the grab and go meals that are happening, while we're out of school and that sort of thing. In emergency medical care, anybody who walks into an emergency room has to be treated. That's, simply the idea behind emergency medicine. All right, and the last one is the right of expatriation. So you have the right, if you so choose, to renounce your U.S. citizenship. If you decide that you just can't take it anymore and you want to move to Canada and you want to become a Canadian citizen, then if you do want to become a Canadian citizen fully, then you would, I believe it's that if you're an American citizen and you move to another country, you can become a citizen of that country. And they would then recognize dual citizenship. But I believe if you are a citizen of another country and you come to the U.S., then you have to renounce your citizenship before becoming an American citizen. Don't quote me on that. I should ask my friend who moved to Sweden and see what that's all about. Because I know that she has her, she obviously is still an American citizen. I will ask her if she has her Swedish citizenship as well. All right. So equal protection of the law. What does that mean? Well, so like I said, in the 14th Amendment, we have what's called the Equal Protection Clause. And it says that no state shall deny any person equal protection of the law, meaning that we cannot apply the law in different ways to different people. And again, that clause was used, as the constitutional question in justifying a lot of laws that were, justifying overturning a lot of laws that were discriminatory against certain groups of people. Like I said before, the Equal Protection Clause also appears in the Fifth Amendment, and it is like this giant bold bullet point here. It says it's been the major constitutional restraint on the power of government to discriminate. So, like I said, they're able to overturn a lot of different laws over the years in the courts by arguing that, having these discriminatory laws violates the Equal Protection Clause of the 14th Amendment, because laws are applied differently to different people. All right, then we have due process clause. We've talked a lot about that in our discussion of civil liberties. These are actually in the same part of the Constitution, both in the 5th and the 14th. It actually states, no state shall deprive a person of life, liberty, or property without due process of law, nor deny any person equal protection under the law. So they're written together in like the same sentence in the Constitution. There's two different clauses. Due process also appears in the Fifth Amendment, and as we know, that's what's been used to incorporate civil liberties to the states. The 14th Amendment part, not the Fifth. And what you have to understand is like equal protection of the law. So who creates laws? Well, governments, right? So the government is who these clauses apply to, not private individuals. So like if I can't say like you're violating my equal protection or due process, because private individuals have nothing to do with the way laws are created nor the way that they're implemented. Now, because of different legislation, though, specifically what I'm thinking of is the Civil Rights Act of 1964, you can sue, private companies for violating the Equal Protection Clause, but really violating the Civil Rights Act of 1964, because they're what's called places of public accommodation. So if you are a private business, and then obviously you are, incorporated and regulated by the U.S. government, then this also applies to you, because you now are under certain restrictions like, fairness guidelines and the EEOC, which is the Equal Employment Opportunity Commission, and that sort of thing. All right. So we have this idea of classifications. So classifications are important with respect to laws in the court system and what have you. What they are they're groups that are created based on common attributes. So like you'll end up in a class based on, race is a classification, gender is a classification, national origin is a classification, that sort of thing. Okay. So the government has created classifications of people, and they sort of use them to decide fairness of laws. So they say, okay, is this a reasonable classification? Is this not a reasonable classification? So the two types of classification, like I said, are reasonable and unreasonable. The Constitution forbids unreasonable classifications that will lead to discriminatory law. And you're like, well, I've never read that part of the Constitution. Correct. It is essentially the 14th Amendment again, this Equal Protection Clause and due process, because we talk about substantive due process, meaning the substance of the laws has to be fair, right? So unreasonable classifications would be unconstitutional because it would not, you'd be applying the law differently to different groups of people, or the laws themselves would be discriminatory and unfair. Okay. So reasonable classifications, in order for a classification to be reasonable, there has to exist a relationship between the class it creates and permissible government goals. Okay. And we'll talk about what that means in a second. Unreasonable classifications is that there's no relationship between the class it creates and permissible government goals. So just the opposite of obviously reasonable. So Just for example, we have a law federally that if you are, sorry, I had to yawn for a second. If you're under the age of 18, you cannot vote. That has been upheld as reasonable. Why? Well, because do you want 6-year-olds voting for president? I mean, you know, when you talk about 18, you assume a certain level of education in most cases. You assume a certain level of maturity in most cases. You also are talking about, 18-year-olds are graduating high school and moving on in their life. Maybe they're moving on to college, maybe they're moving on to trade school, maybe they're going right to work. But a lot of them at that point are taxpayers, right? And so you can argue that now you actually have an interest, like a legitimate, personal interest, current interest in the outcome of elections. Now, there's been arguments brought up that, a lot of 16 and 17-year-olds also are taxpayers and have jobs and should be allowed to vote because, we don't think of elections as having current consequences. We think of them as having future consequences. But that argument hasn't really gained a whole lot of steam. But again, we've decided that it is reasonable to state that you have to be of a certain age in order to be able to vote in federal elections. Now, if we were to say like, okay, well, if you have blonde hair, you can't vote, that's completely unreasonable. There is no decent reason why you wouldn't allow somebody that has blonde hair to vote, right? So any law that creates an unreasonable classification of people and tries to tie it to a government goal or a law is likely going to be overturned if challenged. All right, so we have 3 tests for classifications, and this is how we use these tests to distinguish between constitutional and unconstitutional or reasonable and unreasonable classification. So there's 3 tests, and these go kind of in order of like strictness, so to speak. So rational basis is the least strict, followed by heightened scrutiny, which is more often called intermediate scrutiny, but in your book it's called heightened scrutiny. So I wanted to kind of leave that same terminology there. And then strict scrutiny is the most strict. So in order, rational basis, heightened scrutiny, strict scrutiny. All right, so rational basis, like I said, it's the most lenient. It is the earliest test for reasonable classifications that was put into place, because if you think about it, like from an historical perspective, we weren't thinking about, granting opportunity and granting equality to certain groups of people until sadly pretty recently, with the 50s and 60s and that sort of thing. So this is the only test that was around for a while, because people in government and in the legal realm weren't necessarily apt to extend privileges to any group of people other than, white men, right? All right, so this little aside here, just so you understand what I'm talking about when I say vocab here, the burden of proof, you'll hear that in like a lot of, court cases, or if you're watching court shows or whatever. What the burden of proof means is it's who has to prove that something is legal or illegal, right? So if I'm bringing a lawsuit against somebody, the burden of proof is on me. I have to prove that they did something wrong. If you're prosecuting somebody for, a criminal activity, the burden of proof is on the government to prove that the person they're accusing is guilty. The burden of proof is not on the person to prove their innocence, right? That's where this whole idea of like innocent until proven guilty, right? So when you hear that phrase, they're talking about the burden of proof. Who has to prove their case? Okay, so in a rational basis test, the burden of proof is on whoever decides that they want to attack the law, okay? And in order to win their case, they have to show that whatever law is on the books has no rational or legitimate government goals. In almost all cases of rational basis, the law is upheld. And they use this process, again, like we've talked about, of substantive due process, meaning is the substance of the law fair? And maybe it does exclude people from things, but is there a reason for it? So the example I always use are like medical licensing laws. Okay. So if you want to be a doctor, you can like want to be a doctor all you want. And you can say, well, I know exactly what I'm doing because I watch Grey's Anatomy. And so clearly I should be a doctor. And then you open up a doctor's office and you try to treat patients with zero medical background at all. And so, obviously somebody would say that that's probably not a good thing to do. And they would, sue you for it or whatever. And so, or maybe the government would come in and try to shut down your doctor's office. And you would come back and say, wait a second, you can't shut down my doctor's office. I want to be a doctor. I should then be a doctor. Like, I am pursuing my happiness, right? Isn't that in the Declaration of Independence? Like, life, liberty, and the pursuit of happiness. Why can't I pursue what I want to do? And the government's like, well, no, because you cannot practice medicine without a license. And I'm like, well, that's not fair. I want to practice medicine. And the government's like, I don't actually care what you want to do. It is in the public interest that doctors are licensed, right? So that is a kind of law that, while it does exclude people, because it excludes me from being a doctor just because I want to be, that is a very rational law. And the government has a large interest in protecting the public good by requiring that doctors have to be licensed. So again, in that case, the burden of proof is on me. I'm attacking the law saying this is crap. I should be able to be a doctor even if I'm not licensed. And then, of course, the government will win that case saying, no, there's a legitimate government goal, a legitimate government interest in, having medical credentials. All right, so that's rational basis. Heightened scrutiny, and like I said before, that's more commonly referred to, like in the regular non-AP government world, as intermediate scrutiny. This is mostly used with gender. And in this case, the burden of proof is on the government. So if I believe that I am being unfairly discriminated against because I'm a woman, and I bring a suit against whomever, my company, or Marysville Public Schools or what have you. I'm not going to, just so you know, but like the government would then have to turn around and say, okay, here's why this law is A, rational, B, like follows the rules of substantive due process, C, creates a classification that is necessary, and D, cannot be accomplished in any other way. So like basically the government would have to prove that their interest outweighs my call of gender discrimination. Okay, so this is often used in conjunction with the Civil Rights Act of 1964, which we'll get into in depth in a little bit, probably next lecture now. But in order to win a case like this, you would have, or in order to be sued for this and to win the case, so like the burden of proof on, this company or on the government or what have you, you would have to prove that, again, the objective of the company or the government has a greater role than your being discriminated against because of your gender. And I bring up there's a great case. It never made it to the Supreme Court. It actually was settled out of court. It's a case from 1997, but it's on the restaurant Hooters, right? Which I'm certain I don't need to describe to you. So there was 7 guys applied to be servers at Hooters. And of course, if you can picture servers at Hooters, they're not men. And they sued the company and said that they were discriminated against based on their gender. So they said that Hooters refused to hire us because we're men and we're not women. And this case went to court, and Hooters essentially won. Like I said, it was settled. Like they ended up paying the guys anyway, but probably more so to make it go away. But the ruling on the case was leaning toward being in favor of Hooters because of this provision in the Civil Rights Act of 1964, this BFOQ, which is bona fide occupational qualifications. So in some cases, you can be discriminated against, or what you would think would be discrimination, based on bona fide occupational qualifications. Here's a good example of that too. So if I wanted to get a job at a church, okay, so I wanted to get a job at, as a pastor in a Presbyterian church. Okay, but I'm Jewish. So like they can refuse to hire me, and that is not religious discrimination. It's the fact that they need somebody who is a Presbyterian to lead their Presbyterian parish, right? So that again would be this bona fide occupational qualification. Also, if there is a job in which one of the requirements was, continually lifting, 200 pounds of, boxes or whatever all the time, and I couldn't do that, then they would not have to hire me because I don't meet the bona fide occupational qualifications. So I wouldn't be able to sue a construction company and be like, that's gender discrimination, they won't hire me. They're like, well, can you lift 200 pounds, at a time? I'm like, no, then you can't have the job. So not everything is discrimination, right? But this idea of heightened scrutiny with gender, again, usually, unless you can prove this idea of bona fide occupational qualifications, you're probably going to win your case. All right. Strict scrutiny is the highest level, this highest test for reasonable or unreasonable classifications. So the burden of proof again is on the government. And this time they have to show both a compelling government interest and that there is no less restrictive way to accomplish the goal of their law. So compelling government interest means that the government even cares about it in the first place, or should. That in a compelling governmental interest often also means that there is a compelling public interest in it. And that this law is literally the only way that we can do this. And where they apply strict scrutiny is if it deals with what's called a suspect classification, which we'll get to what that means in a second, or if it talks about fundamental constitutional rights. So interestingly enough, we'll get to fundamental rights in a second. All right, so strict scrutiny often applies to race, and because race is a suspect class. Certain races, right? So people who have been deliberately subjected to severely unequal treatment or otherwise rendered politically powerless. Anyone who falls into that category falls into a suspect class. So any law that restricts anything based on things like race or national origin will be subject to strict scrutiny. And almost every single time the law, it's such a burden of proof on the government to prove that this law is important enough that it has to stay on the books, even though it's racially discriminatory or discriminatory against a national origin. For instance, a really good example of this is the travel bans, right? So not the ones now due to coronavirus, but the ones before, where the president put in place a ban on anyone entering the country from one of 7 nations that were all majority Muslim countries, right? So people brought that to court, and they brought it through the Ninth Circuit at first. I believe it was the state of Washington that brought that case in. They did that, and when that law was looked at, that executive order was looked at, it was looked at through this lens of strict scrutiny, right? So, the government then had to prove that, yes, it is a completely discriminatory law. However, our national interest lies in not allowing people from these countries because they harbor terrorist organizations or what have you, right? So that would be the argument there. The government would have to prove that it is in the public interest for us to not allow people from these countries. Okay. It is also, so strict scrutiny, this is an important point too, is used both when laws are intended to aid or inhibit a particular race or nationality. So if you've ever heard of affirmative action, which we'll talk about in depth a little bit later, but those laws, which are actually intended to lift up historically disenfranchised people, those laws are also looked at with strict scrutiny. Like, are we trying too hard to level a playing field, and in doing so, do we then unlevel it for other people? This idea was sort of seen in Shaw versus Reno, which was that gerrymandering case, right, where the map was drawn to try to create majority minority districts, which was a goal, but then the court looked at it and said, yeah, I get it that you're trying to not diminish the power of the Black vote in this area, but you can't draw districts that are this ridiculous only with the goal of helping Black citizens be able to vote. So that is kind of like one example of where strict scrutiny was applied in a law that was intended to aid the political power of African Americans. Strict scrutiny also applies to fundamental rights. Fundamental rights are rights that are explicit or implicit in the Constitution. We look at fundamental rights being things like the right to travel, the right to vote, which are in all of these different amendments here, 15, 19, 24, 26. Right to travel is in the Privileges and Immunities Clause, of course, of Article 4. And this is something, fundamental rights have been thrown around, that word's been thrown around a lot lately with respect to the stay-at-home order. And there are actually cases that are making their way through the court system right now that are arguing that governors have restricted fundamental rights of people. Specifically, people had brought up this idea of the right to travel through the Privileges and Immunities Clause, the right to property, the right to, they talk about this idea of the pursuit of happiness, and like the pursuit of happiness implies that, you need to be able to work to provide for your family, all this sort of stuff, right? So they're talking about fundamental rights being violated. So when this does go up through the court system, my hope is, because people are arguing fundamental rights, that strict scrutiny tests are applied here. And so again, the burden of proof would be on the government. So if a case was brought against, say, Governor Whitmer, which there are a couple, I think they filed in both state and federal courts. I'm interested to sort of see where that goes. So if they're brought through, or as they're brought through the court system, like, it would be up to the state of Michigan through the governor to prove that, like, the public interest was of a greater concern, specifically as it relates to public health, and her and the state's duty to, quote, promote the general welfare, which is also in the Constitution, is higher or more important than somebody else's right to travel between two residences, in the same state. So it's a super interesting case to follow that really, sort of puts this idea of fundamental rights at the forefront in a way that they have not been in a long time, because we really haven't had to deal with this. So I'm interested to see where those go. People talk about things that they believe are fundamental, but they're technically not. There is no constitutional provision for things like welfare benefits or education or housing. Healthcare is another one that people always talk about. That's a fundamental right. Well, actually, it's not. If you're talking about fundamental rights simply being in the constitutional rights. So, now, there are laws enacted. There are certainly laws enacted to create fairness in education, to create fairness in housing, to create fairness in healthcare. And those have been upheld for the most part in court as constitutional, but they are not fundamental rights because they themselves are not enshrined in the Constitution. They are simply in statutory laws that have been passed. All right. Things that are not yet classifications, or maybe never will be: socioeconomic status, meaning, your money, your economic place in life, your age, which is interesting because we do have laws on the books that do have to do with age discrimination, but it is not a protected class, and probably because it would be like most laws that are on the books that do discriminate against somebody based on their age, or don't allow somebody to do something based on their age, the government has deemed very reasonable. Again, I draw back to the voting thing, right? Or that laws that you have to go to school until you're 16, except for Wisconsin versus Yoder, when we know that was the Amish one where they decided they didn't. There was the compelling government interest wasn't there so much as it was to uphold somebody's individual free exercise of their religion. But in most cases, these age-related things would be upheld. And then also not a classification is sexual orientation and gender identification. And I do say, and I said earlier in this presentation, that we are likely going to see that come in to federal law within the next, I would say, probably decade or so. There are laws that, like I said, that outlaw discrimination against people in these ways, but the Supreme Court has declared some of those laws unconstitutional, but they're just they're not subject to the same level of scrutiny. They're more rational basis ones rather than heightened or strict scrutiny. And like I said before, states have created laws which include these other groups as classifications. Just the federal government has not. All right, that is where we'll end it for today. So unfortunately, that was not your very last ever lecture by me. In fact, that was just one section. So we will come back for more in a little bit.